This is Erica Merrill. I'm the founder of Perfect Legal Video, and I'm very excited to be interviewing attorney Joseph Nivin of New York, and we are going to be talking about fair hearings today after an incident reported from a Child Protective Services. How to get a fair hearing, what happens when you request a fair hearing, and so there's a lot of little details around that. But first, I'd just like to welcome you back today, Joe. Thank you so much for joining us.
Thank you for having me.
Great. Well, let's start off with the first obvious question, which is, what is an indicated case?
Sure. So an indicated case happens after somebody calls the state and reports that a child is being abused or neglected. So once that call is made, then the case is sent to the appropriate, what's called the jurisdiction. So for example, if it's within the 5 boroughs of New York City, then it's the Administration for Children's Services. If it's Nassau County, then it's the Nassau County Department of Social Services. So within 24 hours, the agency has to begin an investigation to determine whether or not a child is actually being abused or neglected. Now, currently, and this is going to change very soon, after 60 days, the agency will indicate the case if there is some credible evidence of abuse or neglect. And that's an indicated case, is after the agency finds that there's some credible evidence of abuse or neglect. The only other alternative is to unfound the case, which means there's no credible evidence of abuse or neglect. Now, there is a bill that's already passed the Senate and the Assembly and is waiting for signature by Governor Cuomo that would change the standard from some credible evidence to what's called a preponderance of the evidence, which means in plain English that if Governor Cuomo signs the bill, that in order for there to be an indicated case, the agency would have to find that there is probably abuse or maltreatment, not simply that there is some credible evidence of abuse or maltreatment. So the consequences of an indicated case can be pretty severe. In most cases, what people are most concerned about is that if somebody applies for a job, either in the child care field or to become a foster or adoptive parent, then the agency that's evaluating the application would see the indicated report, and of course it would reflect negatively upon the person who was the subject of that report. It could also have other consequences. For example, if the person is going through a custody case, the court would be able to see that there is an indicated case and it can be used against somebody in a custody case. Also, if the person gets another report in the future, then it can have a negative impact. I've even seen cases where if somebody moves in with somebody who has kids and the person that moved in has an indicated case, that if for whatever reason the person they move in with, for example, a girlfriend or boyfriend, ends up getting the agency involved in their lives, then that can have negative consequences, that somebody invited somebody into their home with their own children who had an indicated case. It could also have immigration consequences.
Wow, that sounds like it could get pretty messy.
Yep.
Especially if it could cause them to get kicked out of the country or something.
Well, I don't know if it's deportable, if it's a removable offense by itself to have an indicated case. I'm sure there are some cases, like for example, if the allegations were sex abuse, where it could be, but it's more if somebody applies for a green card, that it could reflect negatively upon their character, that they have this indicated case.
I see. So what does it mean if you get a notice of indication?
A notice of indication is a letter saying that the investigation was concluded and that it was indicated.
I see. What do you do once you get the notice?
So in that case, it's really important to write a letter to what's called the State Central Registry, which is the agency that controls all of these records, and to request that it be amended to unfounded. You can, of course, also hire an attorney to do it. Now, currently, the time limits are pretty strict. It's 90 days. But with the bill that's on Governor Cuomo's desk, that would remove the time limit.
I see. So then they could be indicated at any time if this goes through.
As in, you can, right now you only have 90 days to challenge the indicated report, but then the law that, well, the bill that's on Governor Cuomo's desk, if it becomes a law, would provide that there are no time limits and you could request that it be amended anytime in the future.
Well, that makes sense. Um, if they give you a date to go to the Bureau of Special Hearings, what's going to happen there?
Sure. So once you write the letter to the state, then the state can by itself decide to change it to unfounded, but that never really happens. So then you will get a date to appear what's called the Bureau of Special Hearings. The first date will be a conference where not much will happen. You'll meet the attorney representing the agency. And what's supposed to happen is that you're supposed to find out at who the agency plans to call as witnesses at the hearing and what evidence they intend to present. That really never happens. They hardly ever know who they're going to call at the hearing or what evidence they'll present. So what will probably happen is that you may get what's called the case record, which is all the records the caseworker kept, and you'll get a date to return for a hearing. In some cases, the agency attorney may tell you that the agency is considering settling the case, which means that they may agree to have the report modified to unfounded without a hearing. But you shouldn't really expect much to happen the first time that you appear.
I see. And what happens at a fair hearing?
So at the hearing, which is called a fair hearing, if the agency goes forward, in some cases, you might find out when you appear there that they do not intend to proceed and that they're going to agree for the report to be unfounded. But if it does go to a hearing, the agency may or may not call witnesses. Usually, if they call witnesses, there will only be one, which will be a caseworker that you encountered during the investigation. The ACS attorney would ask questions of the caseworker about what happened, and then you or your attorney would have the opportunity to, it's called cross-examine the caseworker, which means ask questions to show either that the incidents never happened or that there's more to it. In other cases, they may simply just take the caseworker's records, put them into evidence, and the attorney will simply read portions of it that the attorney wants the judge to pay attention to. Of course, then you or your attorney would have the opportunity to point out other portions of the record that you want the judge to pay attention to. So after the agency presents its case, then you will have the opportunity to present your own case. If you have an attorney, then your attorney will ask you questions about what happened, and the agency attorney would then have the chance to cross-examine you. And you can call other witnesses as well. You can call, for example, family members. They may have knowledge of the case. You can call teachers, pediatricians, anybody who you feel should has information that you might want the judge to hear. And they would all be cross-examined. You can also present other evidence, like, for example, police reports, photographs that support your position. Now, there are actually two ways to win a fair hearing. The first one is the most obvious, to show that things didn't happen the way that the agency says that it happened. The other way is to show that the allegations, what you're accused of, is not reasonably related to employment in the child care field or to becoming a foster or adoptive parent. Now, what that means in plain English is, even if you did do those things, that it shouldn't really matter if you apply to become a teacher or a school bus driver or to become a foster or adoptive parent. Usually what that means is that you've done services. Like, for example, let's say that the allegations are about drug use. If you can show that you completed a drug or alcohol rehabilitation program, and that you are now clean and sober for a period of time, that even though, yes, you at one point were using drugs or alcohol, or I should say alcohol excessively, it's of course not neglect to have a glass of wine here and there, but that you were once abusing alcohol or using drugs, but that it shouldn't matter if you apply to become a teacher now because now you've been clean and sober for a period of time. So to show that, you can show certificates of programs that you've completed. You can provide character letters even to show that no matter what the allegations are, that you are a good parent. So, and then after that, you will get a decision in the mail about whether the case will remain indicated or whether it'll be changed to unfounded.
Wow. Waiting in the mail for the decision. That's probably like being on pins and needles.
I'm
Um,
sure.
what kind of effects does having an indicated case have on a person that has that?
Well, the main effects that it can have are upon an application for employment in the child care field or to become a foster adoptive parent. It can also affect custody proceedings. Um, Potentially, if you move in with somebody that has children, then the other person can get in trouble for allowing someone who has an indicated case to move in and be around the children, and it could have immigration consequences.
Oh, okay, I see. So you really should be background checking the people that you're going to move in with possibly and have them around your children. Um,
Yeah, I think that in many cases it's really unfair because, I mean, for the most part, somebody that, like, let's say a restaurant that's hiring people wouldn't do this kind of a clearance. So it's kind of unclear how people can be expected to know the past of a girlfriend or boyfriend they're bringing into the home. But I have seen it happen where somebody has, for whatever reason, gotten an agency involved in their lives regarding their children, and then they make allegations that this person neglected their own children because they allowed somebody with an indicated case to move into their home.
so do people find out? I mean, that's one of the next questions. If this hearing comes about, who will be able to find out that all of this happened?
Well, if it remains indicated, then it's anybody who does what's called an SCR clearance, a background check to determine whether or not somebody has an indicated case. Um, but if you win, then it's a lot more limited. Of course, you can get the record, and if you write to the state and you ask for your own record, then you can get it, even if it's unfounded. The agency would have access to that. So, for example, if it's ACS, then they would be able to see that you once had an unfounded case. Law enforcement, in some cases, could get access to an unfounded record. Um, or the state could if they're evaluating how the agency did in this particular case. But if the case is unfounded, then the effects upon you will be, pretty minuscule. In other words, if you apply to be a teacher or foster adoptive parent and the indicated case becomes unfounded, then whoever has your application would not find out that any of this ever happened.
And then, what can having a lawyer do for you in this particular type of case?
Sure. Well, an attorney could, of course, explain to you how the process is going to go. The attorney can explain what your strongest points are, what your weaker points are. The attorney can give you advice, like, for example, to get into services, like a drug program, for example. And an attorney can represent you at the hearing and be able to challenge the agency's witnesses and evidence and also to best present your own case.
Wow, this has been very interesting and informative. And I mean, how often do you come across this type of a case yourself?
All the time. Um, just about an hour and a half ago.
Wow.
I was meeting with somebody who's going through this. I was over there doing a fair hearing on Wednesday. So this is something that I do all the time.
And are they usually founded or like,
Usually, we're successful with these fair hearings. It's pretty often that the agency will simply agree to have it be unfounded without a hearing. Unfortunately, the people that decide whether to indicate cases are not attorneys. So one of the benefits of requesting a fair hearing is that we get the case before an attorney who actually knows what legally constitutes child abuse or neglect. The caseworkers get training on it, but it's nowhere near, but their training is not what the lawyers have.
well, yeah, of course. And so if you didn't have an attorney, you may not even know to ask for a fair hearing. Is that
Right.
ever happen?
Yeah. I mean, when people walk into my office and they have an indicated case, I mean, sometimes they already walk in having written the letter requesting that it be amended. And then other times they didn't know to do that. And they request that I do it for them, which I do.
Well, I'm sure that it's much better written and covers all of the points that need to be covered to get them that fair hearing.
Sure. I mean, we've done this many, many times. So we know what to do to get you over there.
I think that's great news. Is there anything that I didn't ask that you feel like we need to add today to the information for the folks that are listening out there?
No, for anyone that's already got a notice of indication, I think that they should know what to do if they get it. If you are somebody who is still being investigated by ACS, what I'll tell you is that politeness really works. It's very difficult because very often I have people walking in here who are educated people, good parents, and they're wondering why somebody who's very often half their age is walking into their home and asking them and questioning the way that they raise their kids. Even though it's very difficult and it's very tempting to be rude and defensive, what I've noticed is that if you're polite and cooperative and humble, then that can make all the difference. I actually had somebody who was a very educated person, physician, who the first time around, who had ACS on her, was rude to the caseworker because she was wondering why it is that somebody half her age was questioning her ability to raise her kids. And she not only got an indicated case, but I have never seen ACS make such an effort to make sure that it stayed indicated before. They called the police captain in to testify at this fair hearing.
Wow.
Yep. And then while this is going on, while I was representing her, she had another case called in, and I told her, be polite. That'll make all the difference. She was, and it was unfounded. And she told me that she was so glad that this time she knew to be polite because she said the way that she was treated, and more importantly, the result was completely different from the way that it was the first time when she let her emotions get to her.
Wow. Well, my mom always told me that you get more from giving honey than vinegar. Isn't that the way the saying
Yes.
goes, I think?
Yeah, I've heard lawyers say that actually.
Oh, really?
Yep.
Even they know, right? I'm just kidding with you.
Even they know.
That's I mean, they save their being forceful for when it's needed, but honestly, most of the attorneys that I know that are my clients, they're all fantastic people and quite polite and nice to talk to and knowledgeable. So, um, yeah, it's
So
a
we're not what you think. We're not the way that people picture lawyers.
No, you're really not. I put off working with lawyers for a long time, and then I married one and met a whole bunch of really nice ones, and yeah, it's not always as bad as people say.
Oh yeah. I think that sometimes clients are surprised that they think they're going to walk into a courtroom and be sitting there screaming at each other, but it's it's much more polite process than people think.
Yeah, and thank goodness too. I think that like you said, being nice and polite, it really gets you a lot further, and it makes the whole situation more pleasant on everyone.
Right.
Well, good. Well, this has been a wonderful talk today. Thank you so much for coming on live. I know you got a busy schedule, and we will look forward to talking to you next week. I know you're going to send a topic over, and it's going to be just as riveting as today's.
Yes.
All right. So you guys have been listening to Attorney Joseph Nivin out of New York, and I am Erica Merrill, founder of Perfect Legal Video. And we are looking forward to seeing what you're going to bring up next week. And I'll get everybody informed of that probably at the beginning of the week. So keep a lookout for it.
Sounds good. Thank you for having me.
Thank you so much.
Bye-bye.
Bye.